So, very good evening, friends. Today we have the privilege of having with us CS Harish Taneja ji, who is an insolvency professional as well. What we have noticed recently is that the case studies are becoming more and more complex, and there is an orientation towards the practical side. How the insolvency professional, they who have just entered the profession, how they will be handled to, how they will be able to handle a particular situation. Suppose there is some strike, some police authorities come, enforcement directorate approaches you, then how you will handle those situations? There are certain things which are not written in the code. And generally, that code of ethics is prescribed, code of conduct is prescribed, but there is much beyond that. So, how to handle those practical situations in CIRP, liquidation, individual insolvency, personal guarantors? So, I think the best person to guide us is CS Harish Taneja ji. He has been with us on earlier occasions as well, and definitely we will be getting more and more insights from him. So please, sir.
Thank you, Gupta ji, for giving me this opportunity. Before we start, am I audible to all? Am I
Yes,
audible?
sir. Yes, sir. You are audible. We have
Okay.
deliberately muted all the participants so that there is no disturbance.
Okay.
Please, sir.
So,
Converting through, they will be conversing through chat box mainly.
sure.
Please, sir.
Okay. So, with respect to the practical aspects of corporate insolvency process, resolution process, what we have been doing, I'll be able to just take you through our journey, what we have done during this CIRP of multiple of cases which we have been dealing into, in which that includes the real estate cases, the cases where the telecommunication companies were there, the cases where we can say infra projects are there, the cases different, because we have been conducting the process advisory for the insolvency professionals also. And in some of the cases, we have
Please,
in
sir.
some,
Now you, yes, please, sir.
in some of the cases we have been, you know, representing the financial creditors, operational creditors. So the entire gamut of solutions with respect to CIRP we have been providing. The major challenge is, as an insolvency professional, either as a interim resolution professional, either as a resolution professional, and later on, if the company goes into liquidation, then as a liquidator. So we will be taking you through the entire aspect of how we are dealing with the situations when the company is into insolvency resolution process as an interim resolution professional and as a resolution professional. So the practical situations when it starts, the moment CIRP is admitted. Once the CIRP is admitted, we are not there in the once the CIRP is admitted, then we are not there in that NCLT at that time when the admission was done. So how we get to know that we have been appointed as interim resolution professional, or the later on confirmed as a resolution professional, or have been replaced as a resolution professional? Because the code provides the application will be filed by the financial creditor and it will be against that corporate debtor. So the counsel of both financial creditor and the counsel of the corporate debtor will be representing their facts to the on-label tribunal. And we must have given our consent in section 7 application, or in section 9, the on-label tribunal, what they just do, they just have the list of empaneled insolvency professionals with their benches, and they just pick it up and recommend their name, or we can say appoint them as interim resolution professional by passing an order. So the first aspect is, the moment we have been appointed as interim resolution professional, is by the date when the order is being given. Because as per the law, initially it was the CIRP was admitted, and later on, then within 14 days, the appointment of interim resolution professional, there was a separate order that used to be. But now practically what is happening, the moment order is passed, even in that order only, the name of interim resolution professional is there. And there are number of ways by which we get to know we have been appointed as interim resolution professional, because once the order is reserved and thereafter the pronouncement in the honorable tribunal, they straight away mention, yes, the application has been admitted and Mr. So and so have been appointed as interim resolution professional. But we are not there at that point of time. Some of our friends, some of our, even sometimes if we have been tracking it ourselves, then we can also just look into that particular, platform, that whether we have been appointed as insolvency interim resolution professional or not. So the moment we get to know we have been appointed as interim resolution professional, whether from that particular day we should start working or we should wait for the order to be given into our hands. There are two ways. Till the time we do not have any orders in our hand in writing, and if somebody says that you have been appointed as interim resolution professional, then there have been the instances where, though it was mentioned, but later on the name of someone else actually appeared in the order. So my personal view is, the moment we get the copy of order, then we should be treated as that we have been appointed as interim resolution professional. Otherwise, whatever being told by the advocate or any friend or any someone else that you have been appointed as interim resolution professional, we should not believe. And if someone says, then we should ask for the copy of order, because what is written is believed more than what is being said. So the appointment of interim resolution professional is the day when we receive the copy of order. But as per the law, what is the date of insolvency commencement date? The date of insolvency commencement date is the day the order has been passed. Why I'm saying so? There is some gap. There might be some situation. It may take 2 to 3 days by the time you receive the copy of the order. So those compliances will start from the day we receive the copy of order. So the first thing which we need to do is we need to make public announcement. So when we are making any public announcement, the day of insolvency commencement date will be the date when the order has been passed. But for my compliances purpose, if I have received the copy of order, say on 7th, and the order was passed on 3rd, so these 4 days, because otherwise I'll be, in doldrums. How can I publish the announcement when I have received the copy of order later on? So the compliances purpose is the day when you receive the copy of order. But all legal purposes, the day of insolvency commencement date will be the day when the order has been passed. What is the date that has been written in the order? So the public announcement is made, and on the basis of which we have been doing all our 14 days by which they need to submit their claims, and thereafter we need time to verify and all. So all those compliances, thereafter what we need to do is, thereafter, so these 3 days or 5 days or 7 days gap, the day we receive the copy of order, we should file an application for exclusion of this time from the NCLT, because otherwise they will also consider that you might have received the copy on the date when it was uploaded or when it was passed. So in that situation, we file an application to adjudicating authority by saying that we received the copy of order on this date. So these 10 days or 8 days, whatever the time period, should maybe excluded for all the purposes. So my 180 days should complete on these dates. So 180 days will start from the date when I received the copy of order. So, but on labor tribunal, to be on the safer side, we should file an application so that by the time, even IBBI, you must have seen that there are so many situations and so many actions, because IBBI is becoming stricter day by day. And this is the platform where we have been always in the radar of all the stakeholders, and we cannot satisfy each and every stakeholder in spite of our best efforts. But we need to be very, very compliant legally. Whatever is mentioned in the code, whatever is mentioned in the our regulations, whatever is mentioned in the code of conduct, whatever mentioned in all other rules and regulations. So because once the inspection is being done by the IBBI, or any recommendation is there from the adjudicating authority about that insolvency professional, so that becomes a challenge at that point of time to handle. And we also, being a human being, sometimes also commit mistakes, though it is not intentionally, sometimes under the impression of what has already been done in the previous, because there are so many situations, because every company is unique, every company's task is unique, and it is not standardized yardstick by which each and every company will be dealt with. So the moment we have made the public announcement, now the first situation comes. The registered office at which we visited is not in existence. When it is not in existence, what will we do at that point? From where we will get the custody and control of all the assets? The erstwhile management, from which, where as per the law they are bound to cooperate, but there has to be someone to cooperate. If there is no one to cooperate, you went on the registered office, there the structure is there, or there is someone else who is not even known to what was that particular company. And sometimes it is on the chartered accountant's office, sometimes it is at company secretary's office, sometimes it is, there are so many situations, but the crux is the erstwhile management and the records are not there. In you must have seen that, yes, as per the law, we believe that these are the idealistic situation. The moment we will go, the registered office will be there and he will be handing over the custody and control of the assets. But the practical situation is there. We have been fighting from last 2.5 years. Even the director has not come in spite of issuance of non-bailable warrant. So, and there are no assets. We have been, we could not even take the custody and control of those assets in spite of after 2 years, because we are not even aware of where the assets are there. As per the balance sheet, it is written, but there is no asset. So different situations. And then what we need to do at that point of time, when there is no custody and control, there is no erstwhile management that is available. Situation I'll be taking you through: one, when the custody and control, the directors are available. Second situation, when the directors are not available. So if the directors are available and they are not cooperating, then we can have communication and all these, we can, build up our record and then we file an application. And the first stage, when there is no director, because I'll take you through the difficult situation, then automatically easiest one will be covered in that. So when the directors are not traceable, what we can do is we can file an application under section 19 subsection 2 of the code regarding non-cooperation and non-availability of the records. The best in that situation, they'll just here issue a notice. The code, what normally honorable tribunal, what they do is they issue notice to the parties to whom we have made the respondent. So the respondents will be statutory auditors, the respondents will be the company secretaries if they are, the respondents will be, erstwhile management directors, all the directors, those who are there even on MCA portal. So from there we get to know this list to whom we just make the respondents. But before making them the respondents or filing an application, we should have the correspondence with them. So we must have email. We must have shooted the email by which there is no response in spite of 1 or 2 emails. Then we filed an application, notice is being issued. Now the claims are coming up because we made the public announcement. These are the parallel activities we have been doing. One side we are filing an application. Second situation is we are receiving the claims. So how to verify the claims now? Because in absence of the records, can we straight away say that we cannot admit your claim? We cannot constitute the COC. We cannot even entertain the claims because there is no records that is available from which the verification takes place. So in that situation, we cannot say we cannot verify the claim, or we cannot receive the claim, or we cannot, you know, straight away shy away from our duties. That is not possible. In that situation, even there have been the judgments in which it has been mentioned during CIRP, the IRP or RP needs to collate the claim. So the collation of claims, admission of the claims, adjudication of the claims, all these are interchangeably words which you will see also. Until date, we ourselves are not come to the conclusion whether we can reject the claim. If we need to collate, where is the power to reject? So collation of the claim for legal purpose and for academic purpose also, the collation of the claim, which is the duty of IRP or RP as on date during CIRP. He cannot adjudicate the claim during CIRP. So we collate the claim, and collation is the records which have been provided by the creditor. So financial creditor, he needs to file file a claim along with all the proof to prove that the debt was in existence and there is a default, and this is the amount which I have to receive. So all those proof on the basis of which we will verify the documents as these are available with us along with the proof which he has given. If there is some doubt, we seek for the clarification, explanation, or there are certain other documents which we seek for. And accordingly, the COC is constituted. Later on, once the claim has been admitted during constitution, can these claims be updated, revised on the basis of further information? Yes, these can be done. The moment we get to know there is certain information, the payment was made to that particular financial creditor or operational creditor, but he has not disclosed that information to us. And then what we will do, we will reduce that particular claim from the amount of claim which he has already disclosed and on the basis of which we admission was done. So revision of claim is possible. It can be increased further. It can be reduced according to the documents, according to the information which is available to us. So thereafter, we constitute the COC. And the constitution of COC is to be done, as we say, as per the law, within 30 days. But practically, within 30 days, it cannot be, because ultimately within 30 days only we need to convene our first meeting of COC also. So how the first meeting of COC is to be done, there is 5 days notice that needs to be done. So reverse calculation if we just do. So the constitution of COC, when we are doing it, so we try ourselves. So 3 days public announcement plus 14, we just consider from the date of appointment and insolvency commencement date. What we do is we can verification again 714 plus 721, and thereafter we issue a notice of first COC meeting to the committee of creditors after constitution, because ultimately we need to inform to the adjudicating authority. Now the constitution has been done, and when the constitution of committee of creditors have been done and we are filing our report to the adjudicating authority, to NCLT, that the constitution has been done, whether we should wait it is to be recorded or the reporting has been done and thereafter we should take an action, or we should straight away keep our wheel going and do our further acts. Yes, it is a report that is being submitted in which we are requesting the honorable tribunal to take it on record. This is for the compliance purpose. We cannot stop ourselves till the date it is being, the order has been passed by the adjudicating authority that it has been taken on record. It is just for intimation. We need to move on. when this action has been taken after filing and after constitution of COC, the notice is being issued. Now the question comes, when the notice is being issued and we have already filed an application, do we need to again send them the notice on the email ID which is provided as per the MCA records to the erstwhile management, or we can say the directors of the corporate debtor? Yes, as per the compliance, we need to send notice to each and every person, we can say the financial creditor, those who are not related parties, and to the directors of the corporate debtor, though we have already filed an application under section 19(2), but with regard to, in spite of there might be situation, they are proclaimed fugitive offenders, they are not traceable, they are in jail also. The situations are, if they are in jail, should we send them notice if we get to know they are in jail? Yes, even if they are in jail, we need to send them notice in the jail also. So these are the situations where the compliance has to be done in its true spirit manner, irrespective we are being aware of that these people are not traceable, these people are not available. But yes, whatever the records which are available with us, we need to send them the notice of the notice of meeting of committee of creditors. Once the notice of meeting of committee of creditors is done, thereafter second situation comes.
तनेजा साहब,
हाँ जी सर,
एक सवाल है, अगर
बताएं।
पता चल जाए इस जेल में है तो क्या मिलके भी आना चाहिए कि भैया मैं
Yes,
अपॉइंट हो गया हूँ?
बिल्कुल बिल्कुल मिल के आना चाहिए, और मिलना हमारी ड्यूटी भी है.
अच्छा जी,
We should take
ओके सर।
time and we should go and meet, because ultimately my main objective, क्योंकि ऐसी situation आई है,
यस सर, हाँ
रियल
जी।
स्टेट में बहुत ज्यादा आती हैं ये, आपने देखा भी होगा, जैसे अर्थ का मैटर था, इंटेलिसिटी है, जो हम डील कर रहे हैं, जिसमें ये सिचुएशन आई कि जिसमें जो डायरेक्टर्स थे वो जेल में थे.
यस सर।
तो रेजोल्यूशन प्रोफेशनल जाके उनसे जेल में मिले अपॉइंटमेंट लेकर, और उनसे सारे डिटेल्स का इंफॉर्मेशन, जो जो इंफॉर्मेशन अवेलेबल हो सकती थी उन्होंने प्रोवाइड की.
ओके ओके।
और कॉर्पोरेट, क्योंकि ये जो सारी इंफॉर्मेशन है हमें उन्हीं से मिल सकती है, दे आर द बेस्ट.
यस सर।
और आपको जब जेल में मिलते हैं, ऐसा नहीं है कि वो आपको इंफॉर्मेशन नहीं देंगे, क्योंकि हर चीज वहां रिकॉर्ड पे ही है. और जैसे हम भी जब मिलने जाते हैं तो हम उनसे पहले अपॉइंटमेंट फिक्स करते हैं कि इस टाइम पे हम मिलेंगे.
यस सर।
और वहां सारी जो इंफॉर्मेशन जो वो दे पाते थे वो देते थे, और जो नहीं थी वो नहीं मिल पाई. बट यस, द क्वेश्चन इज, इफ दे आर इन जेल, वी शुड गो एंड मीट देम. यस, वी शुड गो एंड मीट देम.
ओके सर, थैंक यू।
हाँ जी.
प्लीज सर कंटिन्यू।
और जब हम फर्स्ट सीओसी करते हैं तो even in there have been the situation, there is no claim at all. The person who filed an application has not submitted the claim. Then what will we do? तो वो अगर क्लेम आ जाता है तो हम सीओसी कॉन्स्टिट्यूट कर देते हैं, और अगर क्लेम नहीं आता कोई भी, then what will we do? Then I'll file an application to adjudicating authority to discharge me. भाई कोई है ही नहीं तो मैं प्रोसेस किस चीज की रन करूंगा? There is no stakeholder for which the CIRP is to be conducted. Then in that situation, the CIRP may be quashed or may be withdrawn, or maybe I may be discharged. And if there is only one financial creditor, yes, there is no such condition. There has to be two financial creditors for constitution of COC. Even the one financial creditor can also constitute the COC. Now situation comes in when there is operational creditor who filed an application, and he is the only one who is there in the COC, and there is no financial creditor. The committee of creditor is only from operational creditor. Whether one operational creditor can constitute the COC? Yes. Even single operational creditor can also constitute the COC if there is no financial creditor. So operational creditor who filed an application, there is no financial creditor, we constituted the COC, and as we say, as per the law, top 18 by value we take into our list and constitute the COC. So again, now question comes in whether these top 18, those who are there in COC, whether voting will be of those 18 will be considered, or the entire list of the operational creditors, though who could not be there in the COC, but actually it is a COC of OCs only. Yes, top 18 will carry 100% for the purpose of taking all the decision, and they will constitute the COC. There cannot be 90 operational creditors for the voting purpose. It is only top 18, they will constitute the COC and they will carry 100% voting. And accordingly, the decision will be taken on the basis of those top 18 only. So I'm just seeing there are some questions also, if that will be there, and if I'll skip someone, I'll request Gupta ji to assist me in that.
Sure, sir, sure.
Then there was a question, what about representative of staff, workmen or staff, or voting? Representative of staff, if yes, employees are there, they can also. That reminds me one of the situation where Section 10 application was filed, and we were giving consultancy to, in the same situation, there was no operational creditor, no financial creditors. Only these employees were there. They were also waiting for their salary to be given. So one resolution professional constituted the COC, and they were not paid from last 1.5 years. And when they came, they were not even aware of the process, what it is. At that point of time, when it was asked to them, you need to contribute so that the CIRP can run. These people were very, very, workman kind of stuff. And if we are asking them to contribute, and they themselves have been very hand to mouth, and Section 10 application has been filed and it has been admitted. There we created a precedent by requesting the Honorable Tribunal to quash the CIRP because there are no assets, and to run the process, these labor people, workmen people, those who have not received their dues or wages from last 1.5 years or 2 years, are not capable enough to make the payment. So the resolution professional request and the consent of COC has also been obtained for release and quashing of CIRP. And that was done. Because whatever is not there in the books, but sometimes as a natural justice and as a prudent situation, if we just look into, then the court goes out of the box and just think of whether this process should be run or this process should be withdrawn, or this process should not be there at all. So in that situation, the process was again withdrawn, and this resolution professional was released because he was not receiving any payment from, because there were no assets in the corporate debtor, and there was no chance of recovery. There was no chance of, and who will make the payment? It is only the labor or the workmen people, those who are available. Because everybody, those who are operations, sometimes yes, financial creditors contribute, but yes, when the financial creditors are there, the chances of recoveries or something, that is also available. But when there is only operational creditor or the employees and there are no assets, they are thinking that we are here to recover the money. We are not here to contribute. We are already suffering. You want us to suffer more. So that is not possible. So they will not make the payment. First payment as per the directions of court of rupees 2 lakh or 1 lakh, whatever the directions have been given by adjudicating authority to submit to the interim resolution professional for the first month. So that deposit is there, but otherwise, even in some situations, that deposit also does not come. And that operations creditor who filed an application, again he becomes absconding. जिसके कॉर्पोरेट डेटर तो absconding था ही था, ऑपरेशनल क्रेडिटर जिसने एप्लीकेशन फाइल की, जिसको 2 लाख रुपए पे करने का डायरेक्शन मिला, वो भी absconding हो गया. Now there is no stakeholder, then the process cannot run. So these are the very typical situations where there is no availability, no money, no chance of recovery, there are no assets. These are situations which is not mentioned in the code. So these are the practical situations when we face and we get to know and we apply to adjudicating authority for appropriate directions. So one more question, what we should do in case in the balance sheet FC are there, but they are not submitting the claim. Yes, if FCs are there and they are not submitting the claim, generally what we do is the moment we, take the charge and we get to know there are financial creditors and they are not submitting their claim. If they are not submitting the claim, we cannot force them to submit the claim. Ultimately, if the only operational creditors, those who have submitted the claim, in spite of being the financial creditors available on the records, and we have made n number of efforts, sufficient efforts to inform them to, and we met them, we requested them to file their claim, but still they have not done it. We will go as per the law and we will submit, the committee of creditor will be constituted on the basis of operational creditors. And second, I just go one step further. If there is only one financial creditor and that too he is a related party, even then the committee of creditors will be from the operational creditors. If no claims are submitted, but IRP knows liability of staff, what is the role of IRP in these situations? So if there are no claims that has been submitted, we need to inform, we need to assist them, we need to, provide the formats, we need whatever the best we can do for them because they are already suffering. And if we are aware of, we should assist them. So all these things should be done, but we cannot fill their form on their behalf. These are the things which we need to take into account. We need to keep ourselves very, very independent. We should not be biased to any of the stakeholder. We should be very independent. We can guide them. These are the forms, get it filled. So now the COC has been constituted. And if there is no claim, what will be the situation? If there is a claim of financial creditor, what will be the situation? If there is a claim of financial creditor, but he has not submitted, then what will be the situation? If second, I'm coming one step ahead. If there is a claim of financial creditor, he filed the claim, but that claim has been verified and it has been rejected. Then again, what will happen? We will constitute the committee of creditors on the basis of operational creditors. So whatever the claims have been admitted, on the basis of that, we will decide whether committee of operational creditors will be there or whether the committee of financial creditors will be there. So once the committee of financial creditors or the committee of operational creditors, that committee will become a committee of creditors. And now first meeting, we are sending the notice. And in the first meeting of committee of creditors, the quorum is to be checked and accordingly all further actions to be taken. Practically what happens is, if the bank is there and the application has been filed by the operational creditor, they will say, we want to replace the interim resolution professional. What is the reason for replacement? They will say, this is our policy. This is our policy. Whether are you satisfied with our performance? They will say yes. Are you satisfied whatever we have been doing? They will say yes. Why you want to replace? This is our policy. We want to take it from our panel. Okay. The replacement agenda. Who can place that replacement of interim resolution professional? He should be the member of COC or anyone else also can, present for replacement. The replacement of interim resolution professional agenda that has to be submitted to, COC by the financial creditor. It can be done in meeting itself. And it is the call of interim resolution professional, or we can say the resolution professional, whether to consider it or not. But yes, as a best practice, we should consider it, and we can place that agenda to it, COC. And after that particular agenda is being put forward, if that 60% voting is there in that favor, then we can consider, yes, this resolution has been passed, and accordingly, who will file an application for replacement? Application for replacement is to be filed by the COC. It is not the duty, and rather we should say, when you are getting this resolution passed from COC, you request that who should be appointed as the authorized person on behalf of COC to file an application if this resolution gets passed. So accordingly, COC needs to file an application for replacement, and that replacement will be done by that adjudicating authority. Whether I will be discharged the day that resolution is passed, no. I need to keep my wheel on till the time, because there cannot be any vacuum during appointment of resolution professional or replacement. So till the time he is not taking it over, we need to work on. Then we will be acting as a resolution professional for all the compliance purpose. We need to appoint the registered valuer. You must have seen in your code that he need to, appoint the registered valuer not more than 47th day. So not more than 47th day or 7 days from the date of appointment. So that 47th day, we need to appoint at any cost, irrespective whether the adjudicating authority has passed for the replacement of resolution professional or not. So these are the compliance things which we need to do, irrespective whether we have been selected as a resolution professional, then it's okay, then it is our duty. If we have not been selected, still we need to appoint the professionals. So these are the things which, in spite of being appointed as, replaced as not being appointed as a resolution professional, but still all these compliances need to be done. So appointment as a resolution professional, replacement of resolution professional we have covered. And thereafter, second step comes in now, publication of expression of interest. So before that, we need to publish information memorandum. So information memorandum में जितनी भी चीजें हम डालते हैं as per the law, if there is something else which is also available, which is not there, but will be relevant for the resolution applicant, we should also include it. All information, whichever is available from any source, but that has to be legal recording. And if there is any information which we later on find that this was not done. So that is the reason we are not giving, this is 100%. This is the most of it which was available to us and we have presented to you. So the publication of information memorandum now, though it is for knowledge purpose only, I don't know, because whether these recent amendments which have already been done on 16th, 17th September will be there in your exam or not.
Sir, they will not be asked in the exam.
Okay.
Actually, our cutoff date is 28th of February 2022. So any amendment made after 28th February is not covered in our syllabus.
Okay. Okay. So then I will not discuss all those. So whatever have been the recent amendments. So information memorandum is to be published, and thereafter, when we publish that information memorandum, can we straight away give it to COC? We cannot give it to COC because ultimately first we need to take the undertaking of confidentiality and non-disclosure. They will not, use it for other purpose for benefiting them and all. So that non-disclosure undertaking, or we can say confidentiality undertaking, is to be taken, and thereafter we can give it to the respective financial creditors. Can we give information memorandum those who are not part of COC to the operational creditor? No, we cannot give if they are not part of COC. So information memorandum is published, given to the committee of creditors, and we seek the information from the financial creditors also. Because as per the law, all the stakeholders, that includes the financial creditor, operational creditor, or other people, those who are statutory authorities, other authorities, they also, if they have information, are bound to provide that relevant information to us. And if we think of, yes, this information is relevant, but they are not providing, we can file an application under 19.2, and they will ultimately, they have to provide. So this is how these things are being done. Can FIR be lodged against the interim resolution professional during CIRP? So there have been the situation where the FIR was lodged against the interim resolution professional or the resolution professional, and that later on Supreme Court had questioned that this cannot be done because of 238 and all. There is separate criminal provisions which will be dealt with by the special court. So FIR with respect to his task, where he has been performing his duties, taking the custody and control and all these things, and unnecessary, as per the law, there was a situation where it is being said that principal occupier will be held responsible as per the Industrial Dispute Act or any other, various laws where it is being said, because we being our best effort to keep the company as a going concern. But sometimes, even you might have also heard that because of that particular bad condition of the road, that interim resolution professional was taken into custody and FIR was lost. And later on, it was quashed by Supreme Court and relevant actions were taken against those police authorities for doing all these. So what is the next step after information memorandum is being published? Then we move for expression of interest. Fixing of eligibility criteria for inviting expression of interest. Again, that has to be passed by the members of COC, discussed with them. We need to deliberate what could be the best one, what should be the net worth, what should be the turnover, those who are companies, those who are individuals. Then there comes whether we can fix the special criteria for those who are MSMEs, for the related parties, because they are the one who has more knowledge about this corporate data than anybody else. So can we fix that particular two criteria, one for the erstwhile management, second one for other stakeholder, other resolution applicants, those who want to submit their expression of interest. Yes, these are the calls which have been duly deliberated by the members of COC, and there accordingly the decision is being taken, eligibility criteria is fixed, and then Form G is published. Then we publish the Form G for inviting expression of interest. Once the invitation of expression of interest is there, and as per the expression of interest, what do? We just see whether all these people, those who have submitted their expression of interest, qualifies as per section 29A or not. Qualifies as per the eligibility criteria which has been mentioned by us during the terms and conditions which were decided by the COC at that point of time. So all these verification, and then we issue a provisional list of PRAs. These are the provisional list of PRAs. And if anyone has objection with respect to these provisional lists, they can raise their objections. If there is no objection, then we issue a list of PRAs. PRAs is basically prospective resolution applicants. So these prospective resolution applicants, if we get to know these are the ones, then we provide information memorandum on the after taking an undertaking. And then all these information which was available to us, if it can be in the PDF form, we can give it to them. Otherwise, we create a data room, then we provide the login password, timings, at which time they can access it. If it is for 24 hours, we can do it. So this is how these are the practical things. If the bulky data is there, then we take the data room. Otherwise, if it can be there in the PDF of, say, whatever the size, and we can provide them, so we can circulate them through mail also. And if any other information they want that it should be given in the pen drive or it should be given in the hard disk, that can also be done by taking the undertaking. So these are the things. Practically what we do is we need to provide the information to the prospective resolution applicant. So all these prospective resolution applicants, once have gone through the information memorandum, and if nobody turns up, what should we do? If nobody turns up, then we again go back to the COC, request them for another expression of interest. Or if we are confident enough, there is not even a single PRA has submitted the expression of interest, we can straight away move towards the liquidation also. But practically what we suggest is we should go for 1 or 2 times at least Form G, so that later on, because there have been the instances in which it has been specifically directed that resolution professional has not made sufficient efforts for inviting the resolution plans and thrown the company into liquidation. So to make the best effort so that we get the prospective resolution applicant, the publication should be done. We should circulate at all avenues, whether it is, bulk email can also be done, because that particular expression of interest should reach to the maximum number of people. This is the intention of the code. That is the reason publication is being done. And if we are doing it and we want to, want the best bargaining and best resolution maximization to happen. So in that situation, we want that best options which are there. And if it is a bigger one, there will be automatically, now initially this used to be the problem, but now each and every investor is being looking for what is the best option that is available in the market, in distressed market. So expression of interest done, then thereafter PRA's list is there, and then information memorandum circulated, and thereafter now the question comes with respect to the resolution plan. So the last date of submission of the resolution plan was there as per RFRP. So RFRP stands for Request for the Resolution Plan. Request for the Resolution Plan is a document which is being made by the resolution professional, in which the complete guidance is being made by the resolution professional to the prospective resolution applicant. किस फॉर्म में होना चाहिए, कितनी परफॉर्मेंस बैंक गारंटी होगी, कितनी BSBG होगी, कितना कौन कौन से पैरामीटर्स को उसने ध्यान रखना है, what is the requirement which the these committee of creditors are also insisting for. So all the information which you want, the format, annexures, the things, whatever information, one is information, second is how this resolution request for the resolution plan will be designed. So ultimately that RFRP is also to be approved by the COC before it is being handed over to the prospective resolution applicant. So that RFRP will carry all the information with respect to submission of the resolution plan. So with respect to submission of resolution plan, what will be the evaluation matrix that will also be there in the request for the resolution plan? What is the expectation of members of COC from the resolution applicant? That will also be there in the request for resolution plan. Formats, how to submit, performance of performance bank guarantees, so binding bank guarantees, the terms and conditions, how this process will take you forward. So all these details will be available in request for resolution plan. So that document is again being handed over to the prospective resolution applicant, and accordingly the resolution plan is being submitted by the resolution applicant on the basis of the guidance which is there in RFRP and the available information that is there with the information memorandum. Now resolution plan has been submitted. Once the resolution plan which is submitted, it is to be submitted electronically, physical copy, so that all details will be available in RFRP how it is to be done. Resolution plan is submitted. Now what is to be done by the resolution professional in that scenario? In that scenario, the resolution professional does first thing to maintain the transparency, because there have been the questions that 4 resolution plans आए, resolution professional ने चारों खोले और उसके बाद एक resolution applicant को बुलाया और उसमें changes करा दिए. In that situation, though it may be perceptions, but we need to be very, very transparent with respect to our process. So what we have been doing it, we have been opening the resolution plans in front of the resolution applicants and the members of COC. We request them send in the encrypted format, password marked, and this will be opened in the COC when they will tell us what is the password. So once it is being known and accordingly the resolution plan have been opened, then we send it for the legal vetting. So after legal vetting and all, then it is being presented to the COC. Now the question comes, if the plan is not compliant, still can we 29A का compliance नहीं है या कोई दूसरी compliance नहीं है, क्या फिर भी हम उसको COC में present करेंगे? There have been the judgments in which it has been sent. It has been, pronounced that even if the plan is not compliant, still the resolution professional is bound to present all the plans to the COC members. So to maintain, this is the best option which is available. These are the options which are available. These are the plans which are non-compliant. So we cannot take our call straight away by not even presenting the resolution plan which is not compliant. So all plans, whether it is compliant or non-compliant, you present it, but we are not asking to put it for the voting. So once the plan is being presented to COC, they will go through. If there is any non-compliance which can be cured, we will ask that resolution applicant, these are the non-compliances, these are the discrepancies in your resolution plan. So the opportunity will be given once to improve it. Then there comes how the negotiations are being done. And as per the law, it is told that resolution plan can be amended once. It cannot be n number of times. So we request all the resolution applicants, do not send the resolution plan amended during negotiations. We request them, okay, negotiations are going on. If you are in agreement, you just send us the draft, one pager that yes, all these conditions which we have raised have been agreed, so that we can move ahead for the second stage. So these are the terms. This is the amount as on date which you are agreeing for it. If you want to increase it, we can further negotiate. So this is the best option which is available. This is the highest amount of the resolution plan that we have received. If we want to increase it further, you can go back and discuss with your commercial team and come back with the highest, or if you are able to match it. So these options, because the option is available to amend the resolution plan once. So during negotiations, the correspondence is being done, but there is no change in the resolution plan at that point of time. And accordingly, the resolution plan, once it has been finalized, yes, this is the final one. And accordingly, we request that resolution applicant, or we request all the resolution applicants, now the final bid or the final amount that has been, and nobody is ready for further increase, you can consider it and accordingly revise your plan so that it can put forward for the voting. So this is how this practically we deal with the resolution plan once it has been finalized, because the change is allowed only once. Resolution plan is submitted and accordingly it is being voted. It is being put forward for the voting. After putting forward for the voting, what they do is, bank normally takes more time. Can we go for 5 days of voting? Can we go for 7 days of voting? Can we go for 3 days of voting? Law says minimum time. It does not say the maximum time. But there have been the situation, even we also opened our voting for 4 days, 5 days, 7 days, 8 days. And because bank takes time for their internal clearances. Some of the cases, head office have their committee, they will just go through the entire resolution plan, and thereafter that resolution plan will be voted upon in their committee, and thereafter it will be said yes or no. with respect to that resolution plan, and that takes time for around 15 days, 18 times. But when it will start, even after the final meeting of committee of creditors has already been taken place, and we are putting forward for the voting. So that time they take it for another 15 days, 18 days. So we keep it, yes, you take your time, and accordingly the voting is being done. And the resolution plan, if it is approved, it's okay. If it has not been approved, it is rejected. Then we move towards the liquidation. And if there is no resolution plan also, we move towards the liquidation. And if all these things are being completely over with respect to approval, then we will be filing an application for approval of the resolution plan with the adjudicating authority. If there is non-approval, then we will be filing an application for 33 for liquidation of the corporate debtor. Now, what will happen? There was a dilemma with respect to once the plan is approved and it takes time, say 6 months, 1 year, 1.5 years. During that period, what is the role of resolution professional? During that period also, the role of resolution professional is to keep the corporate debtor as a going concern. He will not be discharged from his duties after approval of resolution plan. He needs to he will be discharged by the order of adjudicating authority, because he was appointed by the adjudicating authority as an interim or resolution professional. He will be discharged by the adjudicating authority once the resolution plan is approved or even rejected by the adjudicating authority, or that someone else is being appointed as a liquidator, or if he has been appointed as a liquidator, then he will be discharged from the duties of resolution professional and he will take it up as a liquidator. But till that particular point of time, it is his duty to keep the corporate debtor as a going concern, and he will keep on the custody whichever is there with the of assets of that particular corporate debtor. So he is bound to perform all the necessary function. His duty bound to do all the compliances which are there as per the law needs to be done during that particular year, even after approval of plan by adjudicating authority, approval of plan by COC. Because in some of the situation we have also seen that the resolution plan has already been approved 2 years ago, but still I'm working as a resolution professional in spite of after 2 years, because the plan is yet to be approved by adjudicating authority. So the process was for 180 days, 270, 330, but still the court does not discharge us from the duties. We need to perform our duties as per the law. We need to do all AGMs. We need to, get the accounts audited. So whatever the requirements which are there as per the resolution, as per the code, has to be performed, irrespective whether the plan has been approved or rejected. So till that time, the adjudicating authority does not release us. We need to perform our duties. So this is with respect, and what will happen to 19.2? So 19.2 is a parallel process. We are doing our process. So all these things which are there, we need to run the CIRP in its true and spirit manner. And if the records are available, we have added advantage. We'll be able to verify better. We'll be able to, if we have the custody and control of our assets, then what will happen? If the custody and control is not there with us and we have filed an application for taking custody and control, can still the resolution process be done? Yes, we need to inform to the, prospective resolution applicant or the resolution applicant. This is the situation at this point of time. But the resolution plan, when it will be approved, but by that time, practically what we expect is the possession should be in our hands. And we should press the adjudicating authority that this application to be decided on the priority, because the resolution process is entirely dependent on this application. Till the time we will not take the custody, we cannot get the resolution done. So the resolution is to be done only on the basis of the assets which we will be handing over to the prospective resolution applicant or the successful resolution applicant. So this application, we need to press. Ultimately, because adjudicating authorities today's days is also overburdened. There are 28 members out of the total strength, which is 63. So 63 people are required, 28 are handling the entire NCLT. We can expect. So half a day court is there. So 2.5 hours or 3 hours maximum, one bench is sitting, and thereafter second bench again for 3 hours, and the list of applications are say 60. And in these 60 applications, which we are talking about item numbers, in single item also there are 50 applications. High, there are matters which are of, you know, high stakes, just like JP you might have heard of. There are earth matters, even 96 interlocutory applications which are pending. So these lists to be completed, and the time allotted is very, very less. So even the court is also not aware of which application to be heard when. So now it is the duty of resolution professional, or we can say the council of the resolution professional should press it that this application to be heard on priority, because it is the one who is disturbing the entire process, and we want this to be heard on priority. And accordingly, the decision of that particular application is to be on the top priority, because the resolution process can run only on the basis of that application. If that is the situation, we should take an initiative and get it decided at the earliest. So this is how we run the entire process of CIRP. But yes, when the real estate is there, there is a role of AR is also there. So when the role of AR, he represents all those real estate allottees or financial creditors in class, and accordingly he becomes the member of COC on behalf of all the class of financial creditors. And whatever the decision is being taken by those real estate allottees, they will cast their vote, and accordingly on the basis of those votes, that authorized representative will cast the vote in COC. He himself will not take any decision. He himself will not say yes or no on any, resolution without taking the consent of all the class of financial creditors. So because he being the representative, he has to be the representative of the real estate allottees or the class of financial creditors. He himself, though being an insolvency professional, but cannot take any decision on their behalf without their consent. If it has not been if any decision has not been taken by them, he himself sees that yes, this is the good one, we should go for it, but he should not go for it. Because if he goes for it, then ultimately he'll be in trouble. So this is the basic practical case study which we have been, going through in CIRP. If there is any question, these are welcome. I'll request the members, if they have any questions with respect to CIRP, they can raise their concerns. I try to address.
Yes, sir. Definitely, our members are feeling enlightened by the practical experiences you have shared in the. So something on, sir, this insolvency proceedings regarding personal guarantors. If you would like to advise on something.
Yes. So at present, so 94, 95 applications with respect to the personal guarantors. So when the application is being filed by the financial creditor, there have been the situation, दो तरीके से personal guarantors आज की डेट में चल रही हैं जो applications file होती हैं. One is by the financial creditor, second by the resolution professional on behalf of the financial creditor, or we can say on behalf of, second is the person who himself on behalf of that individual. So the petitioner can be the financial creditor, or the petitioner can be himself, he who is going for opting for, as in section 10 application, there is a, as in section 10, there is the corporate debtor who himself goes and file an application. And in section 94, he says that, yes, I want to pursue my individual insolvency. So 94, 95 applications are there with respect to the personal guarantors. So when he files an application, the resolution professional can also file an application, and the declaration and the information, whatever the info. Now, एक practical जो चीज which is disturbing us in filing an application to adjudicating authority by the resolution professional. उसमें आपने देखा भी होगा कि रिट एप्लीकेशंस, बहुत सारी रिट एप्लीकेशंस फाइल हुई हैं कि क्योंकि लॉ के अंदर कुछ डिस्क्रिपेंसीज हैं। वो डिस्क्रिपेंसीज क्या हैं? क्योंकि हम इंडिविजुअल इंसॉल्वेंसी के 25-30 केसेस देख रहे हैं, तो उसमें एक जो सबसे मेजर चैलेंज है कि देयर इज नो अपॉर्चुनिटी दैट हैज बीन गिवन टू द इंडिविजुअल टू रिप्रेजेंट हिज केस। आप देखेंगे सेक्शन 95 के अंदर एप्लीकेशन फाइल हुई, आरपी की अपॉइंटमेंट हुई, आरपी की अपॉइंटमेंट होने के बाद वो आरपी रिपोर्ट सबमिट करता है सेक्शन 99 के अंदर, और 99 की रिपोर्ट सबमिट होने के बाद वो प्रोसेस शुरू हो जाती है। कहीं पर भी जो इंडिविजुअल इंसॉल्वेंसी जिसकी स्टार्ट हो रही है, क्योंकि नेचुरल जस्टिस इज मिसिंग इन दैट सिचुएशन, सामने वाला जो इंडिविजुअल है उसको कहीं अपॉर्चुनिटी नहीं दी गई कि वो अपने केस को रिप्रेजेंट कर सके, वो उस चीज को डिफेंड कर सके। So on that basis that writs have been filed, that there is a question on the constitutional validity of the law, but we are not discussing that because ultimately this is not important for the examination. So what happens is जब हम section 94 या 95 में application file करते हैं, तो वहां पर interim moratorium जैसे ही हम application file करते हैं लग जाता है। What that interim moratorium is? इंटरिम मोरेटोरियम ये कहता है कि जितनी भी प्रोसीडिंग्स हैं, जितने भी लीगल एक्शंस हैं, जैसे हमने सेक्शन 14 हमने पढ़ा था इन CIRP, वैसे ही इसमें 96 है जो इंटरिम मोरेटोरियम के बारे में बोलता है। सेक्शन 96 में बोलते हैं कि जब वो इंटरिम मोरेटोरियम लग गया तो कोई भी उसके अगेंस्ट जितनी लीगल प्रोसीडिंग्स हैं वो सारी स्टॉप हो जाती हैं, कोई रिकवरीज हैं वो सारी स्टॉप हो जाएंगी, वो कहीं पर भी जो उसके सेल और डिस्पोज ऑफ एसेट्स हैं वो नहीं कर पाएगा, कोई फाइनेंशियल क्रेडिटर भी नहीं कर पाएगा, कोई दूसरा बंदा भी नहीं कर पाएगा बिकॉज ऑफ दैट इंटरिम मोरेटोरियम। Whether SURFACE action can be taken during interim moratorium, there was a debate on that also, so that can also not been done. And there was a question, who will bear the cost of the resolution professional, because there is no whisper about the cost of resolution professional in insolvency, in individual insolvency. So ultimately the burden of that cost will be borne by the applicant, or the repayment plan if it is coming up, so that will be again addressed in that repayment plan. So one more thing, 29 is not there in in individual insolvency, because the person who is getting insolvent is himself is giving the repayment plan, how he will repay that particular debt. So whether custody and control of all those assets which is required to be taken, and if there is non-cooperation, then what will happen? So the custody and control, because personal insolvency में जो सबसे ज्यादा challenges हैं, time limit is very very less and we need to perform our duties. अब किसी financial creditor ने अगर हमें claim नहीं दिया, क्योंकि इसमें हम फाइनेंशियल क्रेडिटर, सिक्योर्ड अनसिक्योर्ड क्रेडिटर्स तो बोलते हैं फाइनेंशियल, क्योंकि कमेटी ऑफ क्रेडिटर्स जो है वो फाइनेंशियल और नॉन फाइनेंशियल की नहीं, इट इज ओनली द क्रेडिटर्स व्हिच इज देयर इन इंडिविजुअल इंसॉल्वेंसी। और रीपेमेंट प्लान विल आल्सो बी सबमिटेड ऑन द बेसिस ऑफ द क्लेम्स व्हिच हैज बीन रिसीव्ड बाय द रेजोल्यूशन प्रोफेशनल। द बेस्ट इंफॉर्मेशन व्हिच विल बी अवेलेबल टू अस will be only from that individual only, and whosoever have submitted their claim, and later on if that repayment plan does not talk about, or the person who has not submitted the claim, will that plan be binding on that particular person also? जैसा हमने देखा है कि CIRP के अंदर it is binding on all, irrespective whosoever has submitted the claim or not. But in individual insolvency, if anyone who has not submitted the claim and does not even aware of, that individual insolvency will not, that repayment plan will not be applicable to that particular creditor. Later on, that person can also initiate insolvency in spite of the repayment plan has already been approved by the adjudicating authority. So the repayment plan talks about all the creditors which are there in that repayment plan and who have voted for it and who have been the part of that meeting of creditors and who have been the part of those list of creditors. And even in the secured creditors and unsecured creditors, there is a law with regard to individual insolvency. Secured creditor, before he wants to go for voting, he needs to renounce his security. If he renounces security, then only he can vote in the meeting of creditors. If he does not renounce, because there are two aspects. If his debt is entirely secured, then he'll first renounce his security, then he'll get the right to, vote in the repayment plan. If he does not renounce, he will stay out of that voting, because ultimately that asset will not be part of that repayment plan. So if that asset is not part of repayment plan, then the voting will not take place. Once that decision is being taken, and later on the moment interim moratorium is over or that final moratorium is over, then he will dispose of, that creditor will dispose of his assets if he is not renouncing his security, relinquishes his security. And if he relinquishes security, then he vote. If he rejects again, then bankruptcy proceedings will start. If he does not, if that repayment plan is approved, and so as per the terms of repayment plan, all these assets will be taken care of. Those who are not part of that repayment plan that repayment plan will not be binding on them. And otherwise, who will bear that cost of repayment? Who will bear the cost of resolution professional or the process? If there is no repayment plan, that will be borne by the applicant. That will not be burdened on the meeting of creditors. That will not be there on the, if it has not been ratified. Because the question is, if it has been ratified, they are agreeing for it, that we will bear the burden. If they are not, then applicant will bear the cost. So this is how this practical situation with respect to individual insolvency we have been dealing with, and we'll get the questions and then we will more into.
Thank you, sir. But before we depart, would you like to tell us anything about this PUFE transactions? Some peculiar PUFE transactions which you might have come across and which are not usually observed.
Yes.
Some unusual type of PUFE transactions.
So PUFE transactions, generally what happens is, being a businessman, when the company is in distress, the directors, what they do is, there are two mindset of the directors, which we have seen practically. One, they want to save the company. Second, they want to divert the funds. If they want to save the company and during that saving, they have done something else. How it has happened? उन्होंने पर्सनल लोन लिया, कंपनी को सिक्योरिटी पैसा कंपनी में ट्रांसफर किया, और फिर उसकी ईएमआई जो है वो उनके पर्सनल अकाउंट में जाके फिर उस पर्टिकुलर बंदे को जा रही है. टू इलैबोरेट मोर, कंपनी इज इन ट्रबल. कंपनी जब ट्रबल में है तो उसको लोन नहीं मिलेगा, उसकी एलिजिबिलिटी क्राइटेरिया नहीं बन रहा, पर मुझे कंपनी बचानी है, तो मैंने क्या किया, मैंने पर्सनल लोन लिया, अपनी नेटवर्थ के बेसिस पे पर्सनल लोन लिया. उस पर्सनल लोन से मैंने कंपनी के अंदर पैसा डाल दिया. अब वो पैसा डालने के बाद ईएमआई कहां से जाएगी? ईएमआई जाएगी उस पर्टिकुलर कंपनी से ही. अब वो कंपनी से जब वो ईएमआई गई, तो वो किसको गई? वो गई डायरेक्टर को. पहले डायरेक्टर के अकाउंट में गई, डायरेक्टर के अकाउंट से फिर वो पर्टिकुलर लेंडर को गई. अब वो पर्टिकुलर लेंडर को गई, तो यहां पर ये जो ट्रांजैक्शन है, विल दैट फॉल अंडर PUFE और नॉट? Yes, again it will fall under PUFE because the money has been given to the directors. क्योंकि डायरेक्टर क्या है, उसके अंदर रिलेटेड पार्टी है. अनसिक्योर्ड पहला पैसा जो है, rather than being given to the secured creditor, financial creditor as per the law which is there, but to save the company, he put forward the money into the company, and later on now he is withdrawing it. As per the law, again that comes under PUFE. This is the intention of the corporate erstwhile management, we can say, to save the company. उसने पैसा डाला और उसके बाद वो ईएमआई दे रहा है, पर वो पैसा किस लिए डाला था? कंपनी को बचाने के लिए, पर वो नहीं बचा पाया बिकॉज ऑफ एन नंबर ऑफ रीजंस। सेकंड सिचुएशन है कि वो पैसा निकाले ही जा रहा है रादर देन मेकिंग द पेमेंट, डाइवर्जन ऑफ फंड्स रिलेटेड पार्टीज को हो गया, किसी जो आर्म्स लेंथ बेसिस पे नहीं है वो उस तरह की ट्रांजेक्शन्स उसने की, कुछ पेमेंट्स उसने दूसरे ऐसे ऑपरेशनल क्रेडिटर्स खड़े किए और उनको पेमेंट कर दी। तो सो ऑल दीज विच वर नॉट देयर, जिनसे माल ही नहीं आया और उनको पेमेंट चली गई, और लेटर ऑन बुक्स में एंट्री कर दी कि वो ऑपरेशनल क्रेडिटर्स थे जिनको हमने पेमेंट कर दी, उनसे हमने माल मंगाया, कभी ईवे बिल ही नहीं है उसका। सो इस तरह की जो ट्रांजेक्शन्स है वो जब हम फॉरेंसिक करते हैं या जब हम ट्रांजेक्शन ऑडिट करते हैं तो वी गेट टू नो, और वो पर्टिकुलर उसी बंदे को ही पेमेंट बार बार जा रही है, और उससे बिल तो है पर उसके साथ ना कोई ईवे बिल है, ना कोई स्टॉक की डिटेल्स है, ना कोई चीजें हमें दिखाई दे रही हैं, और ना कंपनी में अब वो स्टॉक आया तो फिर बिका कहाँ, और आज की डेट में वो स्टॉक भी एग्जिस्ट नहीं कर रहा, या स्टॉक कम का आया, पेमेंट ज्यादा की चली गई। तो ये जो सिचुएशंस हैं विच एक्चुअली क्रिएट्स ए रेड फ्लैग कि यहाँ देयर इज समथिंग रॉन्ग। ये हो गया हमारा प्रेफरेंशियल ट्रांजेक्शन्स, जिसमें हमने ये देखा कि प्रेफरेंस हैज बीन मेड टू द डायरेक्टर, preference has been made to the operational creditors, preference has been made to some other unsecured creditor, preference has been made to which is not as per the law. So secured as per 53 अगर हम देखें तो secured creditors को पहले जाना चाहिए तो which has not gone. Then we form an opinion, and after forming an opinion we need to determine, yes, these are the transactions which are PUFE transaction, and accordingly file an application. Now second situation comes in with respect to when there is no participant. We have filed an application. I'm just giving you one example of one of our client. We filed an application where a very renowned personality, because that was a big case, where the amount was paid, say 10 crore to that particular personality, and judge also asked why you have made him a party. My lords, he must have received his fees for being an advocate. And my lords, 15 crores for an advocate, and that too in one go. And the list of litigations which you just came across is not even one or two. So how that money has been transferred, let him come and just explain. And accordingly, but he didn't turn up, and ex parte order was passed. In such situation, when we are going for PUFE transactions, 90% transactions are individual transactions, and the erstwhile management is also not available. The record, which is again incomplete records, फोरेंसिक भी कराया, सब भी तब भी निकल के आया कि भाई बैंक ट्रांजेक्शन्स तो दिखाई दे रही है, ट्रेल दिखाई दे रही है, बट ये उसके पीछे के वाउचर्स क्या हैं वो मिसिंग है। तो उन सब बेसिस के ऊपर जब हमने अपना ओपिनियन बनाया और वी फाइल्ड एन एप्लीकेशन, वो एप्लीकेशन कोर्ट सुनता है, और सुनने के बाद अगर जितनी पार्टीज रिप्लाई फाइल करती हैं, रिप्लाई फाइल करने के बाद इफ द कोर्ट इज कन्विंस्ड, देन अकॉर्डिंगली द ऑर्डर इज पास्ड एक्सक्लूडिंग देम फ्रॉम PUFE। अदरवाइज वो ऑर्डर्स पास होते हैं जो लेटर ऑन दैट बिकम्स डिफिकल्ट फॉर देम टू इवन टू इग्नोर। सो PUFE ट्रांजेक्शन्स में भी इवन कोर्ट जो है थोड़ा सा लीनियंट व्यू रखती है, टेकिंग इनटू अकाउंट द न्यू नेचुरल जस्टिस, बिकॉज दीज ट्रांजेक्शंस, अब लॉ में ये है कि इन द मैनर इट विल बी dealt with, who will be dealing with these PUFE transaction after approval of the resolution plan. पहले एक ऑर्डर आया था कि once the resolution plan is approved, all these PUFE will be zero. अब हमारे लॉ के अंदर ये है कि it has to be clearly mentioned in the resolution plan who will be dealing with this PUFE transaction, and this money will go with whom, whether it will be going to the financial creditor or whether it will be taken by the resolution applicant. If it is to be taken by the resolution applicant, he will be incurring the cost, he will be making the expenditure, and he will be getting the benefits out of it. If it will be, it is already mentioned in the resolution plan, it will be given to the creditors, if it is to be given to the creditors, then rights of that application will be transferred in the favor of financial creditors, and they will pursue that application, and accordingly the fate of that application will be the fruits of those financial creditors or operational creditors or whosoever the creditors or the stakeholders who will be taking the benefit out of it, and they'll bear the cost. So these are the situations where the preferential transactions, where we feel, yes, though it has been done, but yes, fall in the ambit of PUFE, but still we need to file an application as a independent professional. Let the court take a call whether this is a genuine transaction or is a fake transaction. But as per the law, this money should not have been given to the directors. This money should have been given to the secured creditors first. So these and fraudulent transactions where the diversion of funds, that is clearly indicative where the money is going and not coming forward. Related parties को चला गया, different companies में चला गया, जो companies strike off हो चुकी हैं और उसके बाद वो properties उसमें transfer हो गई. तो these fraudulent transactions, एक चीज और भी है. What is the time period for fraudulent transactions and these PUFE? So normally हमने देखा है 66 में there is no time period. तो हम जब उसमें books of accounts refer करते हैं तो 2012 की भी books of accounts देखते हैं, 2015 की भी देखते हैं, 2018 की भी देखते हैं. But otherwise जब transaction audit करते हैं, then we restrict ourselves to 2 years and 1 year. So those 2 years actually give us a thread whether to go back or not. And in practically जो चीजें हमने देखी, once the insolvency application is being admitted, वही 2 साल ले लेती है. अब 2 साल, the date of filing of an application and the date of admission. As per the law, it is insolvency commencement date. But in those 2 years, by the time this application got admitted, the resolution that erstwhile management has done each and everything which was required to be done. Because initially they were not even aware of what the law is. Now the professionals are there all across now, and they also know how these things to be dealt with. So now even the latest changes that has come across, that it should be from the date of filing of an application, not from the date of insolvency commencement date. But as per the examination purpose, we need to remember that it is insolvency commencement date. So in those 2 years, 2.5 years, by the time that insolvency is commenced, and in those 2 years, there is no transaction at all. Because in some cases, when the directors are in jail from 2015, 2016, the application was admitted in 2019. In those 4 years, there is no record. Straight away, we should move towards the forensic, because in last 4 years, nothing has been done. When nothing has been done, then we need to file an application under section 66. So 66, the only application which saves us. Otherwise, PUFE from last 2 years, the nothing is there. So these are the cases where we need to determine whether to go for it or not. And what are the, ultimately it is the duty of resolution professional to form an opinion and to determine. Though we are taking assistance from the chartered accountants or the transaction auditors, but it is not his duty, and he will not be punished, and he will not be, taken into proceedings. Ultimately, it is the resolution professional. The code has cast the duty on the resolution professional to form an opinion and determination. And there is no law in which it has been mentioned it has to be given to the chartered accountant for the audit. So these are the transaction auditor, the word has been mentioned, and transaction audit that has been mentioned. So accordingly, what should be the qualification? It is not mentioned. But we, as a best practice, we believe, yes, they are the one who delve the more into the books of accounts. They are dealing in a better way. They'll be able, they are most capable person. They can, take us through the PUFE, and they'll be able to find it out. And forensic experience, they have much than anyone else. So all these factors practically take us to the people, those who have knowledge of this audit process. Please.
So please, sir, please guide us regarding some provisions related to implementation of the resolution plan. What are the challenges which we receive, which we come across during implementation phase?
So during implementation, what happens is once the plan is approved, in plan we have requested for certain approvals to be given by the respective authorities. I'm just taking you through one of our case where we have got the plan approved. Now it is on implementation stage. That is of real estate project, where the authorities, those who had leased their land to the developer, now they are not transferring because as per the resolution plan, the dues of that particular authority stands extinguished. When the dues stands extinguished and we are asking them to transfer the land in our favor to execute the project without any money. And the debt size is say around 200 crores. Though in books it is very, very easy to say it is applicable to each and every stakeholder and everybody is bound by it. But when there is a dent of rupees 200 crores on any authority, by saying that you will not get anything, whatever your earlier dues are, and now you are bound by the adjudicating authority's order, implement the same, transfer the land in our favor so that we can execute the project. वो कहते हैं उसी से ही करा लो. मतलब this is the kind of response which we received. हम किसी NCLT को नहीं जानते. The first impression which we was not even expected at all, this kind of thing will happen. Then we filed an application to adjudicating authority for transfer, giving the transfer. And they also filed an application that our claims were not considered and all these. So these are the challenges which is coming up when we want to execute. Home buyers are there, they are also with us. They also want their homes back. But ultimately, the person who has the title will transfer once he will receive the money. If that authority is not receiving the money, they are not ready for the transfer. The first challenge which is being faced by all the real estate project resolution applicants is one, that they are not able to take the transfer in their favor. This is the first challenge which we have received. Second, even the adjudicating authority, when that again plan of real estate project, where adjudicating authority also believes that whatever is written in the resolution plan must have been, dealt with in true and professional manner by the resolution professional, and everything must have been taken care of. That is the reason Form H compliance certificate is being received from the compliance report that is being submitted by the resolution professional. Commercial and technical aspect is to be the area of members of committee of creditors. Plan is conditional or not, that again to be, intimated to the adjudicating authority, because conditional plan cannot be even presented to the COC. There was a situation when that resolution plan has already been approved. Land is in the name of an individual. Development rights were given to the corporate debtor. Now the resolution applicant is there, and whether this plan will be binding on that individual also to transfer the land so that the project can be executed. Landowner is someone else. Developer is someone else. And now क्योंकि तब तक तो उन दोनों की आपस की सेटिंग थी. That is कि लैंड उनकी है, डेवलपर मैं हूं, एक कोलैबोरेशन एग्रीमेंट करते हैं, हम आपको चीजें एग्जीक्यूट कराएंगे. रेजोल्यूशन एप्लीकेंट ने लिखा कि जैसे ही लैंड, क्योंकि ये फ्रॉडुलेंट ट्रांजैक्शंस हैं, क्योंकि पैसा यहीं से गया है कॉर्पोरेट डेटर से, 66 की एप्लीकेशन ऑलरेडी फाइल्ड है, दैट लैंड शुड बिलोंग टू द resolution applicant, and ultimately he will be able to execute the project once the land is there in his favor. अब प्रोजेक्ट इम्प्लीमेंटेशन में आ गया। अब प्रोजेक्ट इम्प्लीमेंटेशन में है, अभी 66 की एप्लीकेशन का तो कुछ डिसीजन हुआ ही नहीं है। अब जब 66 की एप्लीकेशन पे डिसीजन नहीं हुआ तो लैंड उसी के पास है, वो रजिस्ट्री करता नहीं है। एग्जीक्यूशन कंस्ट्रक्शन होगी कैसे? उधर से मॉनिटरिंग कमेटी कह रही है कि आपने अभी तक पेमेंट नहीं की, आपने प्रोजेक्ट इंप्लीमेंट नहीं किया। तो मैं आपकी कंप्लेंट एडजुडिकेटिंग अथॉरिटी को करता हूं कि आपने ये एग्जीक्यूशन नहीं कर रहे ढंग से एज पर द लॉ। वो अपनी जान बचाने के लिए एडजुडिकेटिंग अथॉरिटी का सहारा ले रहा है। वो कह रहा है कि आप ये बताओ करूं कैसे? आप ही रेजोल्यूशन प्रोफेशनल थे, आप ही मॉनिटरिंग प्रोफेशनल हो, और रेजोल्यूशन प्लान इंप्लीमेंट ही तब हो सकता है कि जब लैंड जिसके ऊपर प्रोजेक्ट बनना है वो मेरे पास हो। वो लैंड ही नहीं है तो मैं काम कैसे करूं? सो ये वो सिचुएशंस हैं जो डिफिकल्ट सिचुएशन है, जहां प्लान इंप्लीमेंटेशन में बट कैन नॉट बी इंप्लीमेंटेड एट ऑल टिल द टाइम the stakeholder on whom the plan is binding is being directed by the adjudicating authority. You transfer this land in his favor, and SDM को encroachment और ये सारा पूरा custody control possession में आएगा, उसके बाद ही कर पाएंगे। These are those difficult scenario in which the project is at implementation, the plan is at implementation, but cannot be done at all. And implementation में भी हमने ये बोला था कि 3 साल में हम प्रोजेक्ट एग्जीक्यूट करके बाहर हो जाएंगे। 1.5 साल हो चुका है, अभी तो लैंड ही लेने की फाइट चल रही है।
So thank you very much, CS Harish Taneja ji. It was really a wonderful session, and I hope we'll be having more such sessions. So with your permission, we are ending the meeting now. Thank you very much, sir.
Thank you, sir.
And
Thank you.
thank you, sir. Thank
for
you.
giving me an opportunity.
Thank you, sir. Thank you, sir.